Today I'd like to discuss with you another old tax case called the Prevost decision on beneficial ownership. And the case is from Canada. It was decided in 2008 and it involved the following. The appellant was incorporated, this is from the judgment, under the laws of Quebec and is a resident of Canada. It manufactures buses and related products in Quebec. On or about 3 May 1995, the appellant's erstwhile shareholders agreed to sell their shares of the appellant to the Volvo Bus Corporation, which was a resident of Sweden, and the Henleys Group, a resident of the UK. Volvo and Henley were parties to the shareholders and subscription agreement, which we'll come back to later, under which Volvo undertook to incorporate a Dutch resident company and subsequently transferred to the Dutch company all of the shares of Volvo acquired in Prevost. The shares of the Dutch company would be owned 51% by Volvo and 49% by Henley, so it looked something like this. And then the facts go on to describe Volvo and Henleys were both engaged in the manufacturing of buses, Volvo manufacturing the chassis and Henleys the bus body. Prevost was in the same business, building coaches for different types of buses and bus body shells. So this was the bus business. It made sense for Volvo and Henley to go into the North American market by acquiring Prevost at the time. However, things did not go well for Henleys. This comes from Wikipedia, and it shows Henleys Group plc was a major London motor distributor and dealer founded in 1917 in London's Great Portland Street. In 1980, it was taken over by a company associated with Michael Ashcroft, then some years later sold to Yorkshire bus manufacturer Plaxton. Long-established Plaxton took the Henleys name in March 1992, sold motor business in 1997, and with a freed capital became a major player in the bus and coaches business in North America. The Henleys Group, previously known as Plaxton, found it was unable to service the debt on its North American expansion, i.e. Prevost, and liquidated what it could and closed its business in 2004. So these are some of the factual backgrounds. With regard to Prevost itself, the reason for the BV, the reason for choosing a Dutch holding company was very simple, according to Mr. Backstrom from Volvo. Tax was a consideration, but not an overriding consideration. He explains that Henleys did not want the Swedish company and Volvo did not want the English company, which makes perfect sense. I mean, if you're going to have a joint venture, you've got to put it somewhere. Both wanted a company resident in Europe where they have a setup for that type of activity that's not too expensive and where business could be conducted in English. Also makes sense. The choices were Switzerland, Luxembourg, Belgium, and Holland, the latter being very neutral. So from a business point of view, I mean, the acquisition of Prevost made sense. The choice of a joint venture vehicle made sense. The arguments for why it shouldn't have been in one of the joint venture partner countries made sense. The idea that they had something in Holland already doesn't make sense, because if you look, ultimately Prevost BV was run by a trust company, but that you needed a vehicle to put your joint venture in was perfectly legitimate. Mr. Backstrom also testified that PHBV was established as a vehicle for Henleys and Volvo to pursue multiple North American projects. The first of these projects was Prevost. The second was to be a Mexican company, MASA. Okay, so they were going to do more. It wasn't the SPV for one holding only. The original intention was for Henleys to participate in the purchase and that PHBV would hold the MASA shares. However, by this time, Henleys was in financial difficulty, as we saw. Henleys had the option for some years to join Volvo in the Mexican venture, but in the end did not do so. In fact, said Mr. Backstrom, Henleys is in liquidation and does not exist anymore. So that took care of that, and one wonders to what extent the Prevost tax case and the withholding taxes contributed to Henleys' demise. But while they were still there, Henleys and Volvo entered into a shareholders agreement which among other things provided that not less than 80% of the profits of Prevost BV and Prevost and their subsidiaries were to be distributed to the shareholders. And the reason why they had to do this was at all relevant times was because the Henleys needed money, right? So it finally says at all relevant times PHBV's registered office was in the office of Trent International Management BV, a trust company in other words, originally in Rotterdam and later in Amsterdam. TIM was affiliated with PHBV's Vanker Citco Bank. Now this makes the case weaker in my opinion. You say that you want to go where you have substance, but then you end up having your company run by a trust company. During the years in appeal, PHBV had no employees in the Netherlands, nor does it appear to have had any investments other than the shares in Prevost. This does not help their case. And then let's just look at what Article 10 of the Dutch Canadian tax treaty said. It says dividend paid by a company resident in Canada to a resident in Holland may be taxed in Holland. However, such dividends may also be taxed in Canada and according to the laws of Canada. But if the recipient is a beneficial owner of the dividends, the tax surcharge shall not exceed 5%. And this was all about what it was about, whether PHBV was indeed a beneficial owner of the shares. And as we saw in other cases that we discussed about treaty interpretation, a 10-second commercial. If you want to learn more about international taxation or transfer pricing, or treat yourself to an all-round update, or if you want your team to learn or stay updated, please visit my online courses. The judge goes through the treaty and he goes through the commentary, and with regard to paragraph 2 of Article 10, he says the words beneficial owner or la beneficiaire effectief in the Dutch version of the treaty is called uiteindelijk gerechtigde. These words are defined neither in the Model Convention nor in the tax treaty. And he goes on to quote the commentary, which says under paragraph 2, the limitation of tax in the tax state of source is not available when an intermediary such as an agent or nominee is interposed between the beneficiary and the taxpayer, unless the beneficial owner is a resident of the other contracting state. State which wish to make this more explicit are free to do so in bilateral negotiations, but the judge goes on to say Canada and Holland hasn't done that. And then it refers to the 2003 commentaries because the previous was from 1977. And it says, in the 2003 commentaries to Article 10, the convention were modified. Our paragraphs 12, 12.1, 12.2 of the commentaries explain that the term beneficial owner, or in Article 10.2 of the Model Convention, is not used in a narrow technical sense. Rather, it would be understood in its context and in light of the object and purpose of the convention. Sounds like the Vienna Convention, including avoiding double taxation and the prevention of fiscal evasion or avoidance. And we'll come back to this. With respect to conduit companies, a report from the Committee on Fiscal Affairs concluded that a conduit company cannot normally be regarded as a beneficial owner if, though it is a formal owner, it has as practical matter very narrow powers which render it in relation to the income concerned a mere fiduciary or administrator acting on account of the interested parties. So the question remains, was the BV a beneficial owner of the dividends, right? And then the judge goes to Article 3.2, which says, as regards the application of the convention by a state, any term not defined therein shall, unless the context require otherwise, have the meaning which it has under the laws of the state concerning the taxes to which the convention applies. So this would imply that one had to go to Canadian law. And then what is interesting, Canada has an Income Tax Convention Interpretation Act. I've not seen other countries having this. And it says at Section 3, it is hereby declared that the law of Canada is that to the extent that a term in the convention is not defined in the convention, that term has the meaning it has for the purposes of the Income Tax Act, which is totally in line with Article 3.2, right? and not the meaning it has had for the purpose of Income Tax Act on the date of the convention that the convention was entered into. So it's also an ambulatory meaning that if the law changes, the meaning in the treaty should also change, right? And then the obligatory Vienna Convention on Law of Treaties, Article 31.1 is referred to. A treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms in the treaty in their context and the light of its object and purpose, right? What is interesting, if you watch my videos more often, is that last week we looked at Concentrix Services BV, a decision from the Indian Delhi High Court, and there they discussed this issue of common interpretation. And at no point, this is also 2008, the Canadian court or many other courts refer to this concept of common interpretation, even though it is discussed in Vogel. Which is the Bible and interpretation of treaties. It is not many courts that refer to this common interpretation, which if they've done, then they would have run into some Dutch case law interpreting beneficial ownership, and the case might have been much shorter. What they have done, which is interesting, they asked Daniel Luthi, to give some input about the background to the text in the OECD. Now, first, Daniel Luthi was carried forward as an expert witness, but the Canadian Revenue Authorities complained that he was not a professor, therefore he could not be an expert witness. And the court said, nonetheless, I will allow Mr. Luthi to tell us what has been and what he knows about this, and the reason is provided in this text. Daniel Luthi, a graduate in law, worked in the Swiss Ministry of Finance and negotiated about 30 tax treaties on behalf of Switzerland. He was also a member of the Swiss delegation of the OECD Fiscal Committee, member of the OECD Committee on Fiscal Affairs, a member and chairman of the Swiss delegation to the OECD Working Party 1 on double taxation, as well as a member of the OECD Informal Advisory Group on International Tax Treaties. So clearly, Mr. Luthi had a lot of contact with the OECD and with treaties and with dealing with treaties, and he gave evidence about the history of beneficial owner. And the judge in paragraph 54 says, even though the Canadian Revenue Authorities complained, I think we should allow Mr. Luthi to testify on matters on the term beneficial owner and to the issues facing the draftsman of the OECD Convention for more background, more than anything else. And I've never met Mr. Luthi in person, but I've heard many things about him. And he very clearly was a very well-respected member of all these bodies that we read about here before. And so he explained that the term beneficial owner was introduced in Article 10.1 of the 77 Convention. He stated so as to explicitly exclude intermediaries in third states such as agents and nominees. However, Mr. Luthi could find no traces why the term beneficial owner had been chosen in the 77 Convention. Other terms were considered, for example, final recipient, which is much closer to the Dutch text, uiteindelijk gerechtigde, which means the ultimate owner, right? And that there was no, but he also went on to say in paragraph 57 that there was no expectation that the holding company was a mere agent or nominee for its shareholders. In other words, a holding company could be a beneficial owner, right? That's also what the last paragraph last sentence of paragraph 57 says. And then there was this beneficial owner, the conduit companies report. With respect to conduit companies, that is companies acting as a mere conduit, Mr. Luthi referred to the CFA report from 87 on double taxation conventions and the use of conduit companies. And according to this report, the OECD does not deny every conduit company the ability to be the beneficial owner. And it states the fact that the conduit company's main function is to hold assets or rights is not itself sufficient to categorize it as a mere agent or nominee, although this may indicate that further examination is necessary. On the other hand, a conduit company cannot normally be considered a beneficial owner of the income received if it has very narrow powers, performs mere fiduciary or administrative functions, and acts on account of a beneficiary, right? So So one had to tread a fine line between being the beneficial owner and not being the beneficial owner, because one is a conduit company.